And we do have 8 now, so we'll be able to vote on the ones with recusals.
Okay. We ready?
Yes, it is now. Okay, it is now streaming, so yes, you can go ahead and get started.
Okay, I call the Sex Offender Risk Review Board meeting for June 20th, 2024 to order. We are being live on YouTube and want to welcome any guests that are there. Tracy, could I get a roll call, please?
Yes, Mindy Ackerman.
Here.
I know Gerard Armour could not be in attendance. Mandy Ballinger. Ezell Brown, I know he could not be in attendance. Jerry Bruce was not able to be in attendance. James Chapin said he is in court, but as soon as he's out, he'll be joining us. Matthew Connolly.
I thought I unmuted. Here.
Robbie Frederick.
Here.
Katie Gropper.
Here.
Jim Morton.
Present.
Frank Mullis.
Present.
Bert Reeves.
Here.
And Lori Rozier.
Here.
Good morning, everybody.
Good morning.
I'm going to begin by reading our mission statement. Our purpose and mission is protecting Georgia's children and communities at large by identifying convicted sexual offenders that present the greatest risk of sexually reoffending. It is the board's responsibility to determine the likelihood that a sexual offender will engage in another crime against a victim who is a minor or dangerous sexual offense. Assessments are used by SORB to determine the risk level of the offenders. Offenders are classified as level 1, level 2, or sexually dangerous predator. And I also want to remind everybody that following the meeting today, there will be a brief research review training by Dr. Beagle. Have all the members received and reviewed the minutes for the meeting?
Yes.
Are there any questions, concerns, or comments about? Do I hear a motion that we adopt the minutes?
I motion that we adopt the May minutes.
Okay, do I hear a sec? There's a second. All in favor?
Aye.
Aye.
Any
Aye.
opposed? All right, motion.
I'm sorry. I know Lori was the first. Who was the second?
I believe Robbie.
Robbie. Okay. We just need to know names when you speak up for sure to clarify if more than one person does for the minutes. For the next minutes. So, thank you.
Okay, there are reports or officers or standing committees is inactive. Any unfinished business? Any new business by anyone? Okay, and I know Tracy has a lot to talk about today in the executive director report.
Yes, one thing I didn't put in there that I just had not thought about until now is we did attend the Internet Crimes Against Children conference, and Russ and Kirsten Richard had a table there, and this is the first year that we had a table at ICAC. And I feel that it was very successful. We had a lot of people come up and inquire. There was a lot of DCS officers there, so we'll talk to them, and people are just not familiar with SORB. So that was really good. And Russ had gotten that idea and took care of that. So that worked out great. And then the conference itself was really, really good. So really enjoyed being part of that. A lot of obviously related to internet crimes specifically. So it was very enlightening. The next thing is, so since we got clearance that we're definitely getting the budget, I've been starting the process of creating new positions and hiring. So we have put several people in, well, in anticipation of a July 1st start. So I was trying to get as many people hired that was appropriate to begin July 1st. So we have hired several. We've hired several part-time investigators. I think we have maybe all but one part-time investigator filled. So that's really good, and they'll be able to start that training. And then I have a few part-time evaluators and full-time evaluators who've been hired, and they will all start July 1st to begin their 2-week training. And so we're really looking forward to that. We still have the ad out for the clinical evaluators because it'll probably take a while to get all those positions filled. And then I'll also be adding some other positions as I'm working on this whole restructuring. And so part of the restructuring, I'll talk about here in a minute as well, but in reference to new hires, actually have, it's gone a lot better than I was expecting. So I'm really hopeful, fingers crossed, hope it goes well. So excited about that. Now, one thing that has needed to be done and has not is the updates to the board rules, the bylaws, the special rules of order, and the standing procedures. So I sent those out to y'all. Now the statute, which is the board rules, does not, the only thing about that, the board rules is it's legislative. So it doesn't need voted on or anything. I just updated it with all the new laws that have been put in place regarding the board. So for example, we went from, with the reevaluations, they only had 60 days to send in documentation. They now have 120 days to submit documentation. As you probably saw in all those forms, we had to update our name on everything. There were some things changed from the law, like taking out the EMS once they are off of supervision. That's no longer, the part of them being on EMS for life was taken out. So I took that out. So just things like that. So it's very law specific. I just updated it. So the only thing would be if you notice I missed anything, let me know, but I think I got it all. So any questions about that part of it, which is the board rules? So the board doesn't do anything with that. That's all statutory. Okay. The next thing was the bylaws. And again, a lot of it with the bylaws was just changing our name. And then changing, because we used to have people calling in, so we don't have calling anymore. You can call in on Zoom per se, but we use Zoom. So I just changed that part of it. And that was really, I think, all that I changed in the bylaws was updating our name and then adding Zoom instead of call in. Did anybody note anything or have any concerns about that? Was everybody able to look at it and have enough time to look at it? You feel? Okay, so Frank, what I'll do is, you do need to take a vote on the bylaws.
Okay. Does any concerns, questions, or comments from anyone regarding the bylaws and additions or changes to the bylaws, or anything they think, or if they needed more time to review them? Okay, do I hear a motion we accept the changes to the bylaws?
I make
I
a
motion
motion.
that we accept the changes.
So we'll take
Okay.
Lori.
And then Jim.
I'll second the motion.
Jim. Okay. Got it. Thank you.
Okay. Do we need to do a roll call, or can we just do it with an aye?
You can just do it with an aye.
Okay. All in favor of accepting the changes to the bylaws? Can I get an aye?
Aye.
Aye.
Any opposed? Motion carries.
Thank you. The next was the special rules of order. This was a little more changing, really only because of electronic techie kind of stuff that we've changed, again, related to Zoom and related to streaming the meetings rather than people coming in person. So when you look through it, what you're really going to notice is just me changing things to Zoom, explaining about the YouTube and having to post that information for the public. And I also did add loss of meeting room connection. I changed it a little bit to be a little clearer that and we have had this happen, I think, once, where if we lose connection either through Zoom or YouTube, that will stop the meeting until it's resolved. If we can't resolve it in a decent amount of time, then we would just reschedule it. I did put it for the following week, but I didn't know how y'all felt about that. So that might be something for discussion. Does anybody have an issue with it being scheduled for the following week?
I'm okay with it. I don't know if it'd be
What's
as if, with the only comment I'd make is, I'm sure there'll be times where I won't be able, if that happened, but I don't know that it's ever happened since I've started, so I'm okay with it. Jim Morton.
Yeah, and it just have the same rules where we would just need a quorum, you know, for that following week. And then if everybody kind of knows that's gonna happen, y'all can at least anticipate it. And we just kind of function the same way we would any other time. And you do need to take a vote on that, Frank, if we're good
All
to
right.
anything.
And what was that one more time?
So you have to go ahead and take a vote if everybody's good with the changes.
The changes to what? I wanted to make sure the changes to,
Or
There'll
special
be-
rules of order.
okay, the rules of order. Is there any questions, comments, or concerns to that? Okay, all in favor of changes, say aye.
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 Any
Did you wanna-
opposed?
Did you want to make a motion first?
Oh, I'm sorry. I thought we had. Do I hear a motion that we change the, accept the changes proposed?
So moved.
I second.
Okay, Bert and Matthew seconds. All right, now, all in favor of the motion?
Aye.
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 Any opposed? Okay, motion carries.
Thank you. Okay, so the next thing was the board standing procedures. And for that, again, a lot relating to our name change. Where we post, which had changed a while back, actually, we post the information about the meeting within the Egg building where the public can see it, as well as on our website. There's that change. I did add, just for the public to be aware more than anything, because we already do this, but that board members recuse themselves from any case that they had worked on in their regular duties. And then I also changed, so there really wasn't anything stated about how the executive director is hired. It's always been through the board. So I just added that piece so it's in there, and that there'd have to be a panel for that. And then I also, because of restructuring, I'm looking at a deputy director. And if that's the case and that happens, then also we would look at having what the role would be of that deputy director, and also the hiring of that deputy director, which is in that hiring policy that I sent to y'all. For us, if everybody had time to, and you may not have, we may have to look at that for the next meeting, but within this, that was probably the biggest change. And at the end, I removed the 10-year elapse and the 5-year elapse because that is now in the law. We had to make it policy previously, but now that it's in the law, it no longer is required to be there.
Okay, so any questions on that, concerns? All right, do I hear a motion? We accept the changes.
I move we accept.
Second.
Ready, Tracy?
Yep.
All in favor of the changes, say aye, please.
Aye.
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 Any opposed? Motion carries.
Thank you. And then this morning, and I apologize, I thought I put it in with the other forms. This is something completely new, the hiring rule. And with the restructuring of SOAR, we're going to have so many new personnel that I really felt I need to put something in writing as kind of the process of the hiring and how that's all going to work. Did everybody get a chance to peruse that by any chance?
I did.
We did. So again, within this, really the only addition would be filling the vacancy, and how that is done with the executive director, which again is in the other one as well. and then how to fill vacancy of a deputy director, which both of these roles includes the board. The board solely with the executive director, and then the board and the executive director for the deputy director, and then other vacancies, which is already in the bylaws. I hire those other vacancies on my own. So added that, and then screening criteria. Just, and a lot of this stuff honestly is already in the guidelines for DBHCD, and DBHCD takes that from the state laws and then adds their own. And then we have to follow DBHCD's guidelines, the law guidelines. So everybody in orientation gets that information from DBHCD. So I've only added these little pieces that are extra. So it doesn't include everything that's followed, but it includes the specifics to SORB. So I added the recruiting piece, well, applicability, okay, the recruiting piece and qualifications that they have to have, also selection, that they have to have certain criteria to be selected, and also, under filling vacancy, I also changed that to those who are hired on or after July 1, 2024, given the level of restructuring and the things that need to happen with SORB, and to make sure that things are happening the way they need to happen. Anybody who is promoted, changes position, a new hire must reside in Georgia as of that, if that happens as of July 1, 2024, and has to reside solely in Georgia. So those really under filling vacancy was the primary changes. The post-offer requirements are documents that I currently have everybody sign when they start the new position. And then if anything were to change about that, I would just add it and we'd relook at this. But those are probably the filling of the vacancy and the post-offering requirements are the main things that I added to general wording in this particular document.
Any questions, comments, concerns?
And I had met with Frank and Gerard to kind of talk about some of this, especially with the
Mhm.
restructuring, try to get some guidance and some feedback on what they felt was in the best interest of SORB as well. With the restructuring, again, because we're gonna have so many people, I really just want to make sure this works. And so I'm hoping this will help with that.
And we were also, I believe, going to have a committee for the interview of the deputy director. Is that correct?
Yeah, so on the paperwork, what it says is the board will select a panel of board members, and that panel, which will include the executive director, has the following options for filling this vacancy, which is basically interviewing or promoting.
When do we need to set up that? Because I know you're wanting to hire a deputy director fairly soon.
So I can't do anything until this is approved. Once y'all approve that you're all good with this, then
Okay.
I have to, which I've already created the job description. I have to submit it to DBHC to get the position approved and get a number for that position. Then I have to do a critical hire. It has to be posted. So as soon as we get to the posting part, I'll let y'all know and we'll go on from there. So
Okay.
you all will need to, though, discuss who would be on that panel.
Okay, but that doesn't need to be done today, correct?
It does not.
Okay. So do I hear a motion we accept these changes?
The motion that we accept the changes to the hiring rule.
I'm sorry.
Second.
Oh, okay. That was Lori. Who was second?
Bert,
Bert. Okay. All in favor, we accept these changes and additions?
Aye. Aye.
Any opposed?
Thank y'all, I appreciate it. The other thing is, I just want to let you guys know, I try to let you know when we have an in-person judicial review hearing. They've been doing them through Zoom a lot. But on August 5th, there is a judicial review hearing. So if anybody is interested in kind of seeing that process, feel free to attend that hearing. I can give you more information. So if you're interested, just email me. I'll probably just send you all the information anyway, and then you'll have it in case you want to attend that meeting. The other thing is that there was recently 2 judicial review hearings where Kirsten had to testify, and I don't think I shared this with y'all. that the hearings went really, really good. And they continued, and Elizabeth in person, so they continued with the classification that was recommended for that individual, those two individuals, actually. And the next board meeting is July 11th. And that
Before we move on to the review of cases, I think the unfinished business, if I remember correctly, is the nomination for chair and vice chair. Is that correct? Because that's coming up in August.
so yeah, so it will have to be voted on in August for any new person to begin September 1st.
Okay. So is mine and Gerard's position, are we eligible to be voted on, or are we coming off? I can't remember exactly.
You are both eligible, yes, because you finished Doug's term and then you had one term and you get to have two. And
Okay.
Gerard had his one term.
Okay. So we are still eligible. If there's anybody who wants to step in, if you would let Tracy know, is that correct?
Yes, you can let me know, and then what I can do is I can bring up at the next meeting those who've been nominated.
Okay. And then we would vote in July, correct? Or vote in August?
Actually, you don't vote till August. I don't know that it would hurt to vote in July. It's just typically it's in August for the person to begin in September.
Okay.
Really up to you guys.
Okay. Okay. All right. I believe we're now ready to review cases. And Tracy, if you could let us know about the leveling process.
Yes, I do want to mention that James Chapin has joined us as well. So we now have 9 in attendance. So welcome, James. And so with the classification process, we receive information from various agencies when there has been a new prosecution for a registered sex offender. That then goes in our system, and our investigators collect all the criminal documentation that is then sent to our evaluators who review that documentation. They also review community supervision, they review prison behavior, they review treatment behavior that includes also psychosexuals and polygraph examinations, and then any other information that might be submitted. Offenders can submit information anytime that they would like to submit information, and we do not interview the offender. Once the evaluator puts that information together, they score the risk assessments, which is a baseline in determining risk. They look at the dynamic risk factors and then make a recommendation to the board as to what the classification appears to be. And the board has the ability to read them in our system with no identifiers. So they do not know who the offender is, they only know them by number. And then we come to the board meeting and the vote occurs, and then there's subsequent processes, which include the reevaluation and judicial review after that.
All right. And all of the board members have received the copies of the leveling. And is there anyone who did not get a chance to review all those cases? All right. I believe we are ready for the level 1 cases. Do any members have questions, comments, or concerns about the cases that you reviewed?
Yes, hang on, I'm sorry. We're on level 1, right?
Yes.
Okay, I had a question about 10585. And here's my question. The person was initially leveled as a level 2. Somewhere along the way, they were granted level 1 status. There are a few probation violations. Person's got a long criminal history, but there's a few probation violations that relate to their status as a sex offender. failure to register, failure to register, failure to register. And then I see in the sex offender treatment on I think the third page, there's no indication the offender has participated in sex offender treatment since his initial SORT classification in 2013. So anyhow, I don't know. I just would like to know what folks think. I mean, and the person hasn't had a sex offense. It looks like 2017 was the last failure to register as a sex offense. They've had some suspended license and a couple other probation violations that we don't know what they're for since 2017. But so the person has had at least at least three probation violations related to the sex offense and has never completed sex offender treatment. And so my question is how does someone who has never completed sex offender treatment even go from a level 2 to a level 1 in the first place? Like, I mean, is that not a foundational, if you want the carrot and the stick, if you want to have a lesser classification, but you haven't done this basic fundamental thing that you've been asked to do, mandated to do, not asked to do, how do you get a benefit from that? And I'm not necessarily suggesting that the person needs to be bumped back up to a level 2. And I think from what we can see, their recent criminal history doesn't indicate anything that they should. But I just, I don't know why, but I find it bothersome that the person has been violated and violated and violated and violated from their probation, and yet hasn't done the most basic fundamental thing that they've been asked to do. And so is that uncommon, or is this an outlier? Or is that common, or is this an outlier? Does anyone have any thoughts on that?
I can say this is that sometimes in some jurisdictions, sometimes sex offender treatment and even polygraphs are not even required in some jurisdictions. Some jurisdictions with a new failure to register, they get the special sex offender conditions added on and must come to treatment. There's several places I know in South Georgia, like Crisp County is one of those that does that. But then there's other counties that do not put them in sex offender treatment, even if they get a failure to register.
So is it possible that we can pull this case and look at his sentencing documents and figure out if sex offender treatment was mandated?
I can actually speak on this, Bert,
okay,
if you want. So if you look at his criminal history, in 2005, he received the probation violation for failing to attend sex offender treatment as directed, and his balance of that, his sentence was revoked. So, at that point, because he was revoked for the duration of his sex offender sentence, he no longer had a requirement to attend treatment.
Because his probation, if it was a condition of his probation, then that condition terminated by virtue of his sentence. His balance was revoked, so therefore there was no, quote, paperwork over his head to require him to take sex offender treatment. And then, but he was still required to register, which we can see that he clearly has not done over and over again. How does he go from a 2 to a 1? I realize this isn't a reeval. I realize that my comments might be out of place here. When did he go from a level 2 to a level 1? And I'm curious if it was in a time frame that was kind of contemporary with his repeated violations for refusing to register.
Well, this was a court order case, right?
I'm sorry, say it again.
It was a court order case for him to be right. The case was a court order.
Yeah,
I mean, practically speaking, I think I have a little experience with this on the prosecution side, but practically speaking, when we have people who are having a problem complying with the registry, sometimes they look for other remedies, which, you know, a court order to be reevaluated and a subsequent level 1 is then probably going to lead to a petition to be removed from the registry because his inability to comply with the sex offender registry has gotten him in possibly more trouble than his original sex offense. So
Bird, all I can say is I tell people that I treat, and again, this person may never have met a treatment provider, is you're gonna need
Mhm.
treatment because it's gonna reduce your risk for the registry, for the SORB review, whether you're on probation or not. Second,
Well,
the victim was
I'm sorry, keep going.
15. I was trying to go back and read it, but the victim was 15. If the victim had been 16, would it have been a crime? I don't know if that fed into I think this is the case where they said there was no polygraph about forced contact, which I do think that's important. So
Mhm.
I think it's a valid question. Or
If
Yeah,
he had
go ahead.
if he had offended if he had violated the registry with a failure to register in a county like Crisp County, he would have again been required to do sex offender treatment. But apparently, these are wherever he was charged with the failure to registers didn't place special sex offender conditions back on him, where he would be
Do we know
required to
that
do
for sure?
treatment. Well, the fact that he's not. Well, the fact that nowhere did he have a failure to return to treatment violation, because he would have had that.
But how, I mean, he should have had that, but that doesn't mean it was charged. I'm not trying to be, here I go again, y'all. I'm sorry. Not trying to be overly difficult here.
Well, and that's an assumption, seeing that he didn't have to
Right.
return to sex offender treatment. That's the assumption I have, because I know some counties don't provide it, or some jurisdictions don't provide that they have to get special conditions again, and other counties do.
Mhm.
yeah, I mean,
And
the
so,
sex offender treatment is a condition of his sentence. And there are jurisdictions that don't view a registry failure as, it's not a sex crime. It's more of a status crime.
Mhm.
and it's not a risk increasing factor, if I understand correctly, right, Tracy?
Correct. Or at
So-
least what the research is, it's not showing in the research at this point.
I mean, our jurisdiction, if they get a failure to register, we sentence them to sex offender special conditions. But Frank is right, not every jurisdiction does that.
Well,
Yeah,
for what you're saying,
I think my trouble with this is that I don't know. I wasn't in the room when he, or at least I don't think I was in the room when he went from 2 to 1. When I look at this, I'm trying to figure out how that
Well, this is
conduct.
what we're voting on. He's not a 1 yet, correct? Aren't we voting on him becoming a 1?
correct.
Oh, so he's technically right now a 2.
Yes.
Yeah, this is a reeval case.
I thought this was a
Correct,
level
Tracy?
1.
Well,
Well, it
he's
is.
level 1. So this isn't a re-eval like you think of reevaluations. This is a re-level because the court ordered for him to be reviewed again since his last classification.
Well, to me, the only thing this guy has going for him is that it's been 5 years since he's been arrested, and I understand the research and the rubric on failure to register is not a factor. That's hard to. Again, I'm blurring the lines again between, you know, looking at this as a lawyer and not. So here we are back to the retreat, but so this is the point in the moment where he is asking to receive level 1 instead of level 2 status. Is that right?
So, well, I'm sure he'd like to be a level 1. I think
Well, can we ask that? Is it proper? Do we have jurisdiction to ask that he complete a sex offender treatment? That he actually either show proof or that he do that before we vote on whether or not to give him that benefit of that level, or is that something that we don't have the jurisdiction to do?
We can't do that.
Yeah. There are
And if
some states, I'm
treatment-
sorry, there,
If he had been
uh,
attending treatment or complete treatment, it would have been in his DCS notes.
the state of Florida mandates that part of their conditions is they complete sex offender treatment prior to their probation ending. That'd be something that we could add into the law. You know, we could push the request to be added into the law.
I was talking to, this is off topic, but we met with Senator Albers the other day and it sort of collaterally came up that I was on SORB and there was we were meeting about some immigration bills and some of the individuals that get deported and are not leveled for that reason, but then they re-enter and then they're unleveled. And so we were kind of discussing some opportunities for legislation and things. So that may be something worth talking to him about to firm up the laws mandating sex offender treatment. There's no requirement that they do sex offender treatment at all. That's a condition of their probation. And if it's not imposed, then they don't have to do it.
Right.
Right, and
Same
it was
with
obviously
same with
imposed, but then
polygraphs.
right, and that was imposed. He didn't do it. His balance was revoked, and that's the end of that as far as his court requirement. I mean, look, I'm conflicted here. I think that by all means, if you look at the last 5 to 7 years, I can understand why it would make sense for him to go from a level 2 to a level 1. I just have that thing inside of me that's hanging me up that I have a hard time getting over. But
Well, and it's been 11 years since his offense too, I believe, if that's correct.
I think it's been longer than that.
I thought this one was the 17-year, and I had it pulled up, and now my screen completely disappeared.
His arrest date was 2003.
Can
I
you?
thought-
Yeah, so we're looking at
21.
21 years.
So this, okay.
I'm sure that's why.
Yeah, and I understand that, and I'm trying to apply what we talked about and learned at the retreat, and and so I understand that. I have a little heartburn with this, but I'm not gonna hold it up. I'm not gonna try to hold it up.
Just let me clarify. I shared my screen. Can you all see the report?
Yes.
Okay.
Yes.
I can.
I
but
can.
That's my computer. I'm pulling it up on my own. This is 10585, correct? That we're looking at?
Mhm.
Yeah.
For some reason, a lot of these, it looks like half the failure to registers were dead docketed. He did get an 827. Would be interesting to know if he was ordered to treatment. And I can't add them all up, but by the third failure to register conviction, you would think he'd get 30 years probation.
So it has been approximately 17 years cumulatively without engaging in a new known sexual offense. And I know that was a major thing in the, as a risk reducing. Now I know we don't have the evidence of treatment completion, which is one of the things. Those are the two things I think Marcus is talking about today is the treatment, successful completion of treatment and time in the community without reoffending. He does have the 17 years, which is a positive thing. So that's where I was okay with it because of that factor.
I'm confused. We're looking at 2003 to 2023. That would be 20 years, would it not? Or am I just my math's off?
Well,
It's
cumulatively,
pretty
he's been in jail off and on.
Yeah, so cumulatively, yeah. So there's some broken.
Right. Okay.
Yes, yeah.
I'm not clear, and hopefully we'll learn more today, how much weight the completion of the treatment adds, and if that varies per case, Bert. And I'm a treatment provider, so but I would tend to lean with voting yes, that this person be reduced to a 1.
Yeah, I mean, I can live with it. I just hate rewarding what appears to be just a history of refusal to comply. Like it's not like he had one failure to register and registered. Like it, and I get it. It's been like 7 years. Okay, I get it. But like, we're giving this guy a benefit, and he's not indicated interest in. I mean, is he registered now? Do we know that?
I'm
Yeah.
willing to bet the reason that he's asking for the level one, the judge has asked for the level one, is he's going to be seeking to come off the registry. That's my guess.
Yes.
Is there any way? How do we? Is there any way for us to notate in these reports or these files where, let's say today we make a decision to give him level one status? Is there a way to notate that the board agreed with this, but the board is opposed to him coming off of the coming off the registry for at least 5 years or something? Like, is there some way for us to put some note, some flag in the ground on this, so that down the road, when that does happen, someone can see that we had this conversation and we wrestled with this, and so that it doesn't happen in a vacuum in 5 years, and there's something to note that. Is there a way to do that?
That is an Elizabeth question.
Are you talking about noting in the system, or are you talking about noting on the report itself?
I don't know. Well, noting in a way that whoever let's say 3 years from now, let's just pretend none of us are on this board, or we've all forgotten about this guy, and the board reviews, he's trying to come off. How do we remind ourselves, or how do we create a note that, hey, this group of people got together and talked about this and really wrestled over.
I guess my question really then is, who is the note for? Because the board doesn't get involved in removals.
Okay, right.
So 42-119 is the statute that deals with removal from the sex offender registry, and the risk assessment goes to the court, and the court reviews the risk assessment, and they come off of the registry if the court finds that he doesn't pose a significant risk of committing a future dangerous sexual offense. So, I mean, I don't know if it's appropriate for us to put commentary in the reports or not. That's not really my area, but I do think that, at a minimum, we could put there were concerns regarding his level of non-compliance as like a signal. I mean, ultimately, it's the court's discretion, not ours, whether he comes off the registry or not. But I do think in terms of our role on this board and the level one designation, if Elizabeth finds it appropriate, then I don't have any objection to including some language about, like, while the board agreed to a level one, there was significant concern regarding his repetitive demonstration of non-compliance, something like that, which is factual and is not in the court's role. But have we ever had a case where the report was amended to include concerns of the board?
No.
Is that something we could do, Elizabeth?
Off the top of my head, I can't think of any reason why not. I think if you do that, then every board member needs to sign off on the report, because now you're changing the report that was put in front of you in any fashion at all.
So, and I'm assuming that is probably going to be challenged by his lawyer, since it has never been done before. Is that a correct statement?
I can't say one way or the other what his lawyer will do, but I don't know that that's a necessary foregone conclusion. I mean, as Katie pointed out, ultimately it is up to the judge's discretion. This is really just kind of a footnote, if for lack of a better term.
So I think there might be also a need for discussion. Do you think he's borderline 1 and 2? Because he's gone 10 years for this being a reclassification, and now he can come back to us every 5 years. As part of the law. So when they first are classified, they have to wait 10 years to request reevaluation, then it's every 5 years thereafter. So maybe consideration needs to be put on into, do you think he's a borderline case, which then would suggest additional time is needed, or do you think he's a clear one and we can reduce him, or do you think he's a clear 2 and we can keep him where he's at?
I would argue he's a borderline.
Yeah. I think he's a borderline too, but what I would like to know is when he registered.
You want to know his actual registration date, like originally registered? Okay.
Yeah, like it took him. It took him going to jail multiple times. I want to know when he registered.
Well, any of those failure to registers could be he changed jobs without reporting it. He moved without reporting it. You know, he didn't check in for his birthday. The sex offender registry has multiple subsections. And so like I've had failure to register cases where they were living in a hotel and they moved from one room to another room and they got arrested for failure to register. So, you know, some of them are actively evading the registry and not complying, and some of them are just not that bright in terms of their ability to comply with all of the subsections of the statute.
Is it possible for us to find out details about what the terms, because if his failure to register was avoiding registering at all versus a more technical issue with failure to register, like what Katie just said, then that bridges a gap for me. And I'm comfortable. I get a lot more comfortable with him being a level 1 if there's minor technical reasons as opposed to just avoiding to register at all. Is there a way that we can pull this and try to get some clarification on that?
You sure can.
Then I would move that we pull 10858 and to get more information on his failures to register and then reconsider in time.
I'll second that.
Okay. All in favor of pulling this case till more information is gathered? Do I hear, do we need to vote on it, Tracy? As far as individually?
Yes, we can do that.
Okay.
Okay, and so we're looking at pulling 10585. Mindy? James? James Chapin? We'll come back to you. Matthew?
Aye.
Robbie?
Aye.
Katie?
Aye.
James?
Aye.
Jim?
Aye.
Frank?
Aye.
Bert?
Aye.
Lori?
Aye.
It's been pulled.
Okay. Any other questions, comments, or concerns about the level 1 cases? All right, do I hear a motion we adopt the level 1 cases that have been presented to the board for review?
So
I move we accept.
So I have Bert
Do I hear,
moving first,
and yeah, Robbie second.
Robbie second.
Okay, can I get a roll call?
Yes. Mindy?
Aye.
James?
Aye.
Matthew?
Aye.
Robbie?
Aye.
Katie?
Aye.
Jim?
Aye.
Frank?
Aye.
Bert?
aye.
Lori?
Aye.
They pass.
All right, we'll move on to the 10 level 2 cases. I believe I had a recusal on the level 2.
There's actually 3 recusals. So Frank, you're recused from 17213. Matthew, you're recused from 21515. And Jim, you're recused from 31432. Did anybody notice any other recusals that should be there? Okay.
Are there any questions, comments, or concerns about the level 2 cases? All right, do I hear a motion that we adopt the level 2 cases as presented to the board?
I motion that we adopt the level 2 cases.
Second.
Judge Lori and Bert.
Yes.
Okay. Mindy,
Aye.
James,
Aye.
Matthew, other than your one recusal,
Aye.
Robbie,
Aye.
Katie,
Aye.
Jim, other than your one recusal,
Aye.
Frank, other than your one recusal,
Aye.
Bert,
Aye.
or Lori,
Aye.
they all pass.
All right, we're moving on to now the 8 sexually dangerous predator cases. Are there any recusals for that?
There was one recusal, Matthew 25080.
Okay. Do we have any questions, concerns, or comments about the sexually dangerous predator cases? All right, do I hear a motion we accept the sexually dangerous predator cases?
I motion that we accept the sexually dangerous predator cases.
Second.
Is that
Right.
Bert?
Yes.
Yeah.
All right, and Tracy, I think we're ready. Is that correct?
Yes. Mindy, any questions or concerns by any of the SDPs?
No, and my vote is aye.
James, any questions or concerns by any of the SDPs?
No, my vote is aye.
Matthew, other than your recusal, any questions or concerns by the SDPs?
No, my vote is aye.
Robbie, any questions by any of the SDPs?
No questions, aye.
Katie, any questions or concerns by any of the SDPs?
No, aye.
Jim, any questions or concerns by any of the SDPs?
No and aye.
Frank, any questions or concerns by any of the SDPs?
No, and my vote is aye.
Bert, any questions or concerns by any of the SDPs?
No, aye.
Lori, any questions or concerns by any of the SDPs?
No, my vote is aye.
They pass.
All right, we move on to the 4 reevaluation cases. Are there any recusals on the reevals?
We did not detect any.
Okay. Any questions or comments or concerns about the reeval cases? All right, do I hear a motion that we adopt the reeval cases?
I move that we adopt them.
Do I hear a second?
I second Jim Morton.
Thank you.
All right, I believe we're ready for a roll call.
Okay. Mindy, any concerns about any of the reevaluation cases?
No, my vote is aye.
James, any questions or concerns about any of the reevaluation cases?
No, my vote is aye.
Matthew, any questions or concerns about any of the reevaluation cases?
No, my vote is aye.
Robbie, any questions or concerns about any of the reevaluation cases?
No questions, aye.
Katie, any questions or concerns about any of the reevaluation cases?
No, aye.
Jim, any questions or concerns about any of the reevaluation cases?
No and aye, it's my vote.
Frank, any questions or concerns about any of the reevaluation cases?
No, and my vote is aye.
Bert, any questions or concerns about any of the reevaluation cases?
No, aye.
And Lori, any questions or concerns about any of the reevaluation cases?
No, my vote is aye.
They pass.
All right, we want to thank everybody for their reviews this month. The evaluators and the investigators, again, thank them so much for their hard work. And we thank Tracy for all the new hires. She's had a lot of interesting times interviewing people, and we'll be getting with you about the committee if you're interested in being on the committee in coming months, and also if you're interested in the not the director position, but if you're interested in the chair position or the vice chair position, let Tracy know as well.
Can I ask a question? I don't know if I'm the only one. I think maybe a couple of us are coming up on the end of our term. At the end of August, is somebody gonna reach out to us, or how does that work? This is my first term.
That is a really good question, Katie. I have reached out to them like a couple months ago, and of course, with everything going on there, she told me that the governor's not doing anything right now at that point. So I've kind of been trying to give him a break. And then I need to reach out again because typically those who've just served one term will be reappointed for a second term, and you'd receive notification about that when that happens. Usually, I think it's done around probably August, September, or July, August, because I think it's reconfirmed September 1st, if that's when you started before. And then those who've already filled 2 terms now, what the interesting thing is, and it makes it very hard for me to keep up, is if somebody's put in a seat that somebody else did not complete their term, you finish their term, and then you get your own 2 terms on top of that, potentially. So there might be some people who have completed their actual 2 full terms. I've asked her about that as well. And so I know they're just kind of working on that kind of stuff and figuring all that out.
Gerard's on like his 10th term, so.
Oh. I know.
So,
I will say this, that I do believe, but again, don't quote me, because poor Gerard, every time he thinks he's done with his 2 terms, they decide he wasn't done, and he keeps getting reappointed, and we're happy to have him. There's a possibility he's done with his 2 terms, so keep that in mind in thinking about the vice chair. I would just say that just in case, have that in mind if he were to roll off come September.
So Katie, you've been here 4 years already?
I know time flies when you're having fun.
I would have, I honestly didn't know it was 4 years already. So that means I guess I'm like 6. Is that right? I finished the 2 and started. I got a letter from you'll get a letter from the lieutenant governor. From what I understand this time, that's what I got, a letter from the lieutenant governor saying that I'd been reappointed. So.
Oh, okay. Yeah, no, I joined in 2020.
Yeah. Wow.
Crazy how fast. Yeah.
All right. We will adjourn, and then Marcus will come on. Is that correct?
That is correct. When you adjourn, I'll turn off the YouTube and the recording, and then we'll take about 5 minutes so that Marcus can get set up.
Okay. So do I hear a motion that we adjourn?
So moved.
I hear a second.
Second.
All right. I believe that is it, and we are adjourned.
And